Morning, everyone. Thank you so much for being here on a snowy morning. I'm Pat Clendenen. I'm a shareholder here at Davis Mom, and I'm really here just to give a little sales pitch for part 2 of the planning session, which is on March 8th. And today's session was a great introduction to what we're going to be doing on March 8th, because as a result of all this planning, or the lack of planning, you're going to get litigation. You're going to get litigation as a result of a data breach. But I think more importantly, the lessons that we hope you've learned from today's session will help you prepare for any kind of litigation. Contract litigation, employment litigation, because the kind of collaboration that you heard virtually everyone talk about today, I think is very important. It's a great lesson. The CIA principles, the segregation principles, the WISPs, the training are very valuable to your organization, whether or not the litigation relates specifically to data breaches. The training, the control, the professionalism that you want your employees to have in all of their business communications, for example, are really principles that come from the C-suite. So Nick's slide about this really being a C-level process, where I think you can also get some valuable input from your employees, particularly salespeople, people on the road, employees, to help better understand how to run your organization and give your employees some freedom to operate. So you'll see what we plan to cover. Breach response, preparation. We'll do a little bit of a review of what we covered today, and then depending on what kind of problem you have, it could be class action litigation, it could be government investigation and litigation, it could be derivative litigation, it could be an employee leaving and stealing trade secrets, which is another development that I think is very important, and something that I think the literature and the communication these days doesn't really cover as much, and it goes back to this whole planning process that Rob and Nick and Chaz talked about, is that, yeah, your customers are very important, your employees are very important, but your trade secrets, that's your non-patent, valuable secret information, should not be accessible to the rank and file. And that could include customer lists, it could include blueprints. So we'll talk a little bit about the various permutations, and then as Chaz correctly pointed out, insurance is a contract. And I've had situations where businesses have been hit with class actions and haven't had the right coverage. And their agent didn't do a good job, and they probably didn't get their counsel involved in that process. So I think you need specialized expertise on the legal, on the insurance, and on the IT side to really effectively solve this problem. And I think just from my own business litigation and IP litigation perspective, you'll be in a better position as an organization to prepare for and respond to any kind of litigation. So with that, I wanted to open it up to questions. I have some questions for the speakers if nobody else does. Does anyone have questions for any of our speakers today? No? Okay. Nick, can you talk a little bit about working with organizations to help get their employees involved in the process to make this process effective from a security standpoint, but also allow employees essentially to get their jobs done?
Yeah, it kind of goes back to that triad. Yeah, it goes back to the CIA triad. Really, you need engagement across the board to develop an effective program. Some of the standards that make IT security people like me happy typically won't make the rank and file happy. You know, those are restrictive passwords, those are the latest and greatest technical controls. So you have to develop a broad consensus amongst the different stakeholders in the organization in terms of the level of acceptable security. You don't want to limit access to critical systems, but you do need to recognize that it is a compromise of maybe its availability, maybe its integrity, but you want to find out what the organizational preference is, where you kind of fall in line, what you can lock down, what you can't, and the bigger the buy-in you can get from all the different stakeholders, the more effective that program's going to be, because everyone has a stake in it.
Okay. Pat, I was going to say one thing before you go. We are running a little bit late here. I don't know whether people want to have a final couple wrap-up questions, or do you need to head out to your day? We're happy to do a few more of just to wrap the program up, but if people have to bail and head off to their jobs.
Well, people have to leave, please leave. I just had a couple.
That's fine, yeah.
So Chaz, with regard to this process where you're working with companies, do you often see law firms or lawyers, either in-house or outside counsel, getting involved with you to help negotiate these policies and get the coverage done?
Yeah, great question, Patrick. I was actually talking to Nick about this earlier. This is, without a doubt, not an IT. This isn't reinsurance for the IT department. This is a global purchase for the entire organization, and we actually request that a number of key people within the organization get involved in the application. First and foremost, it generally starts with either a risk manager as well as a CFO, IT certainly, HR, and absolutely legal, because there's a number of different questions throughout the application, and the application does look a little bit like a risk assessment, but you'll see it hit a number of different areas. Where most importantly legal would step in would be on the contract side. So, do you have indemnification wording with your vendors? Do you have written contracts with your vendors or clients that talk about privacy and security or corporate confidential information, whatever it may be, depending on the industry you're in? Then there's going to be questions for IT. Do you have firewall technology? Do you encrypt? There will probably be additional questions for legal on the media side, so any content that's disseminated. Do you have social media websites that release content? Is that approved by legal before it gets out into the internet or social media site? And then obviously there is a big play on the IT side specifically for records. We really haven't talked about records too much today. But what a record is a unique individual file. But it's important to note that records do not include duplicates. So if you're a hospital and you have 10 records on Chaz Bellingrath, that's not 10. If you have 10 files, on Chaz Bellingrath, that's not 10 records. That's one record. So we work a lot with IT, CFO, legal, to try to come up with that record count. And some organizations will give us an exact record count, and some will say, like with law firms, it's much more difficult because you guys could have information going back to 1979. So, how do you kind of figure out what that rough estimate is? How many customers do we have on an annual basis, times how long do we keep it for? But one reason why we ask for record count, first and foremost, is underwriters will ask for it. But secondly, that's one way we, as brokers, will come up with appropriate limits for you. So, a lot of our clients will sit down with us and they'll say, okay, I understand we need to move forward with this coverage. How much should we buy? Should we buy 1 million? Should we buy 3 million? And a lot of times it comes down to the record count because it depends on how much information you have that could result first and foremost in breach response costs, but also liability down the road.
Yeah,
so
and
it is very much a number of people that come together to complete it.
And the other thing that's interesting, just speaking from my own experience as an attorney, is that our clients are starting to audit us. And so what's very important for you and your organization is to understand that your obligation with regard, and the litigation could encompass data that you have sent to a vendor to work on. It could be a copy shop, it could be an accounting firm, it could be a law firm. And if they haven't gone through this process that Rob outlined from the beginning, you're potentially on the hook. Absolutely. For those exposures that you didn't directly cause. So that has to be a part of the process, and the kind of litigation, which we'll talk about at the next seminar, when you're looking at insurance, because coverage counsel for the carriers will really look at the language in the claim and the policy very carefully. So you have to look at it very carefully. It has to include investigations, and it has to include, particularly if you have government-regulated information, has to include government-related litigation, because that can break the bank as much as a class action. So, hackers are lazy, but they're opportunistic. So, and litigation can come from lots of different areas. I think as Gary, one of our partners here, pointed out, it could come from a disgruntled employee, it could come from a vendor, it could come from a hacker. But as everyone on the panel really articulated very well, this is an ongoing process. This isn't just, hey, I got a policy, I got a WISP, I did the training, put it on the shelf, and we're done. So with that, questions?
I just have a quick question. I mean, I'm at a law firm. I work with a lot of financial institutions, and they're all requiring us to agree that all of our emails are going to be encrypted and all of our files are going to be encrypted. And they're sending us emails and files that are not encrypted. Or it's even this weird blend where half the emails will come in their encrypted system and half won't. And I wonder if you could address maybe the liability for that, and also what you're seeing, I don't know, in the market, if that's a normal thing or somehow that's about to change. But it seems it's completely chaotic, and yet we have all certified and promised that we'll encrypt.
Yeah. I mean, it's an understandable process. It's required by Massachusetts law. You're supposed to control your vendors. And again, as a law firm, you're a vendor to a particular company like a bank or a financial institution. They have to have controls and have appropriate controls in their contract with you that govern what you're doing. Now, the content of that is, and the other part of that is that financial institutions are getting pushed very hard by regulators to be able to make sure that they have strong protections in place. And it's a pain in the ass from the professional services side, because you're dealing with these often difficult requirements, and sometimes they don't make it easy for you to comply with it as well. I don't really have answers on that other than say it's happening, and you have to try to work with the vendor as best you can, or with your client as best you can, to be able to come up with reasonable rules that you can live with, because you don't want to agree to something you can't live with. And if it's this type of issue coming up in the field, then I guess you have to circle back to them to say, hey, you're not making us able to do our side of the equation. You need to help us on that. But you're right, if you put your finger on a big issue for professional services firms.